Hello students, I hope you are doing well. So let's start this lecture. I am Guneet Kaur and I'll be delivering a lecture on Sales of Goods Act 1930. So we'll be discussing about the important topics of the Sales of Goods Act 1930. So let's begin. First of all, let's understand what do you mean by the contract of sale. What is the meaning of contract of sale? So according to section 4, subsection 1, a contract of sale is a contract whereby the seller transfers or agree to transfers the property in goods to the buyer for a price. So students see, a contract of a sale is a contract between a seller and the buyer where the seller agrees to transfer the property in goods to the buyer for a price. So there is a sale transaction happening. So that sale transaction is a contract of a sale where the seller gives the property in goods to the buyer for a some price. So you can see the highlighted figures, that is the highlighted text says the seller transfers or agrees to transfer the property in goods to the buyer for a price. For example, on 1st June, A agrees to sell computer to B for rupees 20,000 with the intention of transferring the ownership to him. B agrees to pay the price in 5th June. It is sale or absolute contract. So basically, what do you mean by a contract of sale? A contract of sale is one where the ownership of the goods is transferring immediately for a price. So there has to be a transfer of ownership willingly. So moving ahead, sale versus agreement to sell. So there are two different terms. One is sale and one is agreement to sell. So what do you mean by sale and what do you mean by agreement to sell? I can give you a brief definition, a brief introduction about these two terms. So first, understand what you mean by sale. We know that a sale is a transaction between a seller and a buyer where seller voluntarily agrees to transfer the ownership of goods to the buyer for a price. So what do you mean by agreement to sell? In agreement to sell, the sale transaction will take place on the basis of fulfillment of some condition or at a future date. Where the sale is not happening immediately, where the sale transaction take place at some future date, I can say that is known as an agreement to sell. So it's one important question from the examination point of view. What is the distinction between sale versus agreement to sell? So let's look upon the basis given. Number one is transfer of property. So in sale, the property is transferred immediately, whereas in agreement to sell, the property is transferred to the buyer at some future date. So you can see that in sale, the property is transferring immediately, whereas in agreement to sell, property is transferred at some future date. Next basis is nature of contract. So sale is basically an executed contract. We can say that sale is an executed contract because in sale, both the parties, the seller and the buyer, these both parties have completed their obligation. Sale has taken place, so this contract is known as executed contract, whereas agreement to sell is known as executory contract, because in agreement to sell, the sale has not taken place. It will take place at some future date. So it is known as an executory contract. I hope it's clear. Next is nature of rights. So buyer acquires jus in rem, that is rights against the whole world, whereas in agreement to sell, buyer acquires jus in personam, right against an individual. So whenever a sale transaction is taking place, once the sale has been done, now the buyer has the right against the goods, whereas in agreement to sell, the sale has not taken place. The seller has the right. Next is risk of loss. The buyer has to bear the risk of loss in a sale transaction. For example, in sale, the good has been transferred from seller to the buyer. Now, the ownership of the goods lies in the hands of the buyer, so buyer has to bear any risk of loss, whereas in agreement to sell, seller has to bear the risk of loss. Because it's an agreement to sell. Sale has not yet taken place. The ownership still lies in the hands of the seller. So the risk of loss still is with the seller. Next important basis is right to resell the goods. So in sale transaction, seller has no right to resell. Seller has no right. I can highlight it for your reference because sale has taken place. The ownership of the goods now in the hands of the buyer in sale. So seller has no right to resell the goods. Whereas in agreement to sell, seller can resell the goods and convey a good title to the third party. In agreement to sell, there was an agreement to sell. Sale will take place. So the seller has the right to, resell the goods to any third party. For example, I'll give you an example for this. A enters into an agreement to sell his car to B after 5 months at some future date after 5 months. So now A got a better deal from C, a third party. So this A has still the right because the sale has not yet taken place. There was already an agreement to sell. So A can resell the goods to C, but A will be liable to, pay damages to B because he is breaching that agreement to sell. I hope that is clear. Moving ahead. Insolvency of seller. So in sale, official receiver or assignee of the seller is under obligation to deliver the goods to the buyer because ownership lies with him. So in a sale transaction, if there is insolvency of the seller, so insolvency means the seller is not able to, give that good, but he is under the obligation because since the sale has taken place, the buyer has the right against the good. So seller is liable to, deliver the good to the buyer. Whereas in agreement to sell, the buyer cannot recover the goods from the official receiver of seller, but where he has paid the price, he can get only rateable dividend from the property of the seller. So in agreement to sell, the buyer cannot recover the goods because the ownership has not yet transferred. Next important basis is insolvency of buyer. No matter whether the buyer has declared as insolvent, seller has to deliver the goods to the official receiver or assignee, that is the buyer, because the goods are in his possession in sale. Whereas in agreement to sell, where buyer has not paid the price, seller is under no obligation to deliver the goods to the official receiver or assignee of the buyer. So in agreement to sell, we can say that, if buyer has not paid the price, the seller is under no obligations. Seller is not liable to deliver the goods to the buyer because the buyer has not yet paid the price. So there are very two important case laws. Aldridge versus Johnson 1857 in sale versus Johnson versus McDonald. So these two important cases are there. In Aldridge versus Johnson, A agreed to exchange with B 100 quarters of barley at 300 per quarter for 52 bullocks valued at 1,000 per bullock and pay the difference in cash. Here the contract was a sale as the consideration was partly of goods and partly of money. So in sale, what matters is that you are transferring the ownership of the goods and in return the buyer is paying you the price. It doesn't matter whether the price is paid in the form of money or in the form of partly in money or in the goods, but the price should be, complete price should be paid to the seller. If both the things are present, there is transfer of ownership of goods plus you are receiving a consideration, that is the price. It is known as a contract of sale. So let's look at the case law. Johnson versus McDonald 1842. A agreed to buy from B certain quantity of aluminium. The ship carrying the aluminium was yet to arrive from London. Held, it was only an agreement to sell and not sale, as ownership could be transferred to A only on arrival of the ship. So Johnson versus McDonald says that two parties enter into a contract, that I'll buy a certain quantity of aluminium, condition that the ship arrives from London. So We know that agreement to sell is a contract. It's an agreement on the basis of fulfillment of a certain condition. It is not a contract of sale. It is not a sale because the ship has not yet arrived. Moving ahead, the next important topic is subject matter of the contract of sale, which is goods. Subject matter of the contract of sale. So what is the main thing happening in a contract of sale? We have discussed that sale takes place between a seller and the buyer, and the subject matter for that sale is goods. So what is the definition of goods? What all are the things that come under the term goods? We just know that goods could be stock, goods could be inventory, goods could be your assets, but there are hundreds of things that could be termed under goods. So let's see section 6 says that goods from the subject matter of contract sale. According to section 2 subsection 7, the term good means every kind of movable property other than the actionable claims and money, and include stock and shares, growing crops, grass, and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. So it means that good could be all the movable property. Not just movable property, we'll see in the following definition that intangible properties like goodwill, patent, trademark, all these things come under the definition of goods. So section 2 subsection 7 says good means every kind of movable property other than the actionable claims. So the term actionable claims means any arrears, past arrears. For example, if you have to recover rent for past 6 months, so that cannot be termed as a good. So actionable claims means past debt, and good means stock and shares, growing crops, anything which is attached to the land or forming part of the land comes under the subject matter of the contract. So the subject matter of the contract of sale also include a lot of things. So first is all kind of movable property. Things attached to the land can be the subject matter of contract of sale. Growing crops, grass, trees, crops, everything comes under the term goods. Going ahead, electricity, gas, steam, water, all these things come under the ambit of goods. The decree of court of law comes within the purview of goods. Electricity signals such as cable TV signals, electricity, gas, steam, water, all these things are termed as goods. Stock, and after the allotment shares, they are also included in the goods. Bank FDs, fixed deposits, receipts, they are also known as goods. Animals and birds, I think nobody have ever thought that animals and birds, they are also termed as goods. Foreign coins or old and rare coins, they all come under the subject matter of goods. Not only tangible goods, intangible like goodwill, copyright, trademark, patents, all these things come under the ambit of goods. They can be treated as goods and may form the subject matter of contract of sale. So all these things, whether it's an animal, whether bird, whether fixed deposit receipts, whether shares, growing crops, all these things are a part of the term or come under the ambit of goods. They are known as the subject matter of sale. Moving ahead, our next topic is classification of goods, section 6. So goods can be classified into 3 types. Goods can be existing goods, goods can be future goods, there can be contingent goods. So let's understand what are all these types. What are existing goods? So goods which physically exist and are owned and possessed by the seller are known as existing goods. So you can see that I have highlighted that goods which physically exist, which are present at the time of contract, are known as existing goods. For example, A visits Honda City car showroom where there are 6 different models are displayed and he agrees to buy a white color Honda City car. This is a contract of sale of existing goods. He wanted a car. He went to the showroom and he saw that there are different models of the car and he wanted one out of those six. The car was actually present. So this is a contract of an existing good. Next topic is future goods. So goods which are not there at the time of making a contract, which are yet to be manufactured or produced or acquired by the seller after making the contract. So existing goods are those goods which are present at the time of making a contract of sale, whereas future goods are those goods which are yet to be produced, yet to be manufactured. So let's look at the example of the future goods. A agrees to sell all the apples which will be grown in this garden next year. This is an agreement to sell future goods as apples are not in existence. For example, a person enters into a contract with the farmer that, I'll buy all your apples which you will grow in the coming season, maybe after 6 months. So this is a contract of sale of future goods because the goods are not yet present, they are not yet existent, they are still to be produced. So the next topic is what are the contingent goods? Section 6 subsection 2 lays down that there may be a contract for the sale of goods, the acquisition of which by the seller depends upon a contingency which may not happen. In such a case, goods sold are called contingent goods. So the term contingent means depends upon happening of an event. So we often study in accountancy that there are contingent liabilities. So the term contingent means something which is happening of an event. For example, goods which depend upon happening of an event. Let's see the example. A milkman agrees to sell 5 kg of milk provided cow yields the milk. This is a contract for the sale of contingent goods and can be enforced only provided the cow yields the milk. In this case, the contract of sale is taking place for the contingent goods. Provided the cow yields the milk, then only the contract of sale takes place. I hope it's clear. In this case, the contract of sale is already formed, but the goods are not yet in existence. They are dependent on certain event, certain happening of an event.